5 seconds. The learned counsel for the appellants is right in saying that the appeal having been filed within time, initially the question of condensation of delay under section 5 of the Limitation Act does not arise. Obviously, the said action would not be attracted because there was no delay in filing the appeal as such. So, the only question which falls for determination is whether the delay in refiling the appeal should be condoned or not. It may be pertinent at this stage to say that the Punjab High Court rules and orders, being statutory rules, have the force of law. Reference in this context be made to Tej Krishna versus the Delhi Cloth and General Mills Co. Limited and others, AIR 1950, East Punjab 195, and Bikram Das versus the Financial Commissioner Revenue Punjab. In the latter authority, a full bench of the Punjab and Haryana High Court held that rule of procedure have been framed by this court in exercise of its rule making power available to it under sections 122 and 129 of the Code of Civil Procedure or clause 27 of the latter's patent. So, the said rules have the force of law. Therefore, non-compliance with any rule framed by this court prescribing a condition precedent or a necessary condition to the filing of an appeal would render the memorandum of appeal liable to rejection. One of the questions referred to the full bench in the said case was whether Rule 3 of Chapter 20 of the Punjab and Haryana High Court rules and orders was mandatory or merely directory. The full bench answered the question saying that the provision contained in the said rule was imperative and thus violation would entail penal consequences. The same question cropped up for consideration before the Supreme Court in the state of Punjab, another versus Samlal Murari and another, while holding that the Rule 3 of Chapter 2C, Volume V of Punjab and Haryana High Court rules and orders, which requires the enclosing of 3 copies of documents mentioned in the rule along with the latter's patent appeal, was directory in nature. Their lordship held that where copies of all the 3 documents prescribed have been furnished but not 3 copies of each, the commission or default is only a breach which can be characterized as an irregularity to be corrected by condensation on application by the party fulfilling the condition within a time allowed by the court. It is pertinent to notice here that the Supreme Court declined to condemn the delay in the said case with the observations discretionary exercise of power by a court cannot be lightly interfered with by a court of appeal, and we are loath, therefore, to upset the order of the High Court declining to condemn the delay, there being nothing preserved or irrational in the exercise. So, even though the decision of the Punjab and Haryana High Court with regard to the mandatory nature of Rule 3 of Chapter 2C was overruled, their lordships in terms recognized that it was discretionary with the High Court to condemn the delay non-compliance with the requirements of the rules and orders framed by the High Court or not.